cannot come to court every time and charge suspects in a manner that exhibits unreasonableness. My Lord, now just a quick rebuttal. My Lord, counsel for DPP has not responded to the petition. My Lord, this petition is not about double jeopardy. I need to mention that. It's not about double jeopardy. My Lord, what we are saying is that there is a basis that the trial has laid down. When you charge suspects in court and the trial proceeds, there are two issues that can happen. The suspects can be acquitted or the suspects can be convicted. So, my Lord, double jeopardy has not crystallized yet. But what we are saying is that it amounts to unfairness of the trial process if the suspects who are on that path of double jeopardy or double atrefois acquittal, they are on that path. They have a legitimate expectation that the trial process will be completed and they'll be either convicted or acquitted. My Lord, they are on that path. So, my Lord, what our petition is based on the fact that there's a basis. The trial process lays down a basis for the two options. And therefore, it amounts to unfairness. It is completely unfair if you charge the suspects again. My Lord, counsel for EACC is partly true on one question, which is a legal question, that the trial process, my Lord, that the new trial, the new charges must exhibit new facts. My Lord, if there are new facts, and my Lord, I will urge you to look at the documentation. If there are new facts, then our case is weak. But my Lord, the doctrine of new facts works against the respondents. Because, my Lord, if you look at, let me just point to one issue to demonstrate that the state has not rebutted that burden which they're supposed to rebut. My Lord, EACC has said that there's a distinction between the two trials. That the first trial is about procurement, and the second trial is about payment. So, my Lord, if that position was true, then it will mean that in the first trial, the first charge, there will be no questions about payment. And the defense counsel will never be submitted with documents about payment. But, my Lord, this is what happened. And, my Lord, you can read for the charges yourself. My Lord, look at paragraph page 37 of the document. You will see that doctrine completely extinguished. You will see the state is talking about payment voucher. My Lord, in count number 4, my Lord, it's talking about payment voucher of 18 million. And, my Lord, I don't want to go through all the details because it reopened my case. I'm just making that distinction. And, my Lord, the subject matter of 5,000 bucks is in all the charges in the first charge. And, my Lord, the question of payment of again 18 million is in the second count. The second charges, my Lord, sorry. The second charges. So, my Lord, that is why we raised concerns. We didn't want to raise these concerns if the charges were different. We raised concerns. We said, but this payment voucher you gave us earlier on, my Lord. You gave us this payment voucher in the first trial. An opportunity was available to you to charge the suspects. And we are saying that opportunity was lost once the trial process continued. And, my Lord, the trial process is not controlled by the defense counsel. It is controlled by the court. And as submitted earlier, the court gave them ample opportunity, my Lord, ample opportunity to ensure that they put their house in order before the trial process proceeds or starts. My Lord, they lost that opportunity to put their house in order. And therefore, in our humble submission, we said, DPP, in attempting to charge suspects again on the same set of facts, my Lord, the doctrine of new facts is not applicable to them. Instead, the doctrine of same facts exists to prevent them from charging the suspects afresh. And, my Lord, really that is the essence of the trial process. And we are saying it is so unfair to the suspects if that were to happen. Like in this case, DPP is attempting to do so. So, my lord, it is not true that DPP exercised his powers reasonably. DPP exercised his powers unreasonably. And my lord, public interest is greater when we all respect the rule of law. We need to be governed by the rule of law, such that all the rights which suspects have in Article 50 must be adhered to. So my lord, in summary, I submit that in rebuttal that the respondents have not discharged that very critical burden which the petitioner has made in his petition in terms of the allegations of unfairness of the trial process. My lord, I'll be happy to answer any question if you have any. Thank you.
No, man, just thank you, because that's what the purpose of this conversation. And what you submitted this morning carries more weight than the work you have done here, because it gives me the true note on how I then can be able to grasp the discussion I'm going to have and come back to you. The thing is that, when you are interested in Madam Gititi, of around 70 pages, and another one, another 20 pages, you need an